So this case, Barker versus Riverside County Office of Education, 2009 case, 584 F 3rd, 821. It's the Ninth Circuit Court of Appeals. And this is a PDF, so I can't really change this. I was getting ready to put a space there. Anyway, I've already marked this up. So Susan Lee Barker was employed by the Riverside County Office of Education as a resource specialist program teacher for students with disabilities. This document is on my Substack. It's called adarights.substack.com. So you can go there and get this with these markups on it. Look at it. I'm kind of gloss over this, but she sued her employer for constructive termination based on an intolerable work environment. Barker's complaint alleged that her supervisors retaliated against her after she voiced concerns that they were not complying with the requirements of federal and state law and how it provided services to disabled students. And of course, I'm paraphrasing here. The district court dismissed Barker's lawsuit for lack of standing. Barker argues that she has standing to sue the Riverside County Office of Education pursuant to the anti-retaliation provisions of both Section 504 of the Rehabilitation Act of 1973 and Title II of the Americans with Disabilities Act. So let me say here real quick that Section 504 of the Rehabilitation Act applies to federal agencies or people who receive federal funds. So if there's an entity that receives federal funding in any way, they're subject to Section 504. So you can use that to get equal access as someone with a disability. It's not the same as the ADA, but it's the precursor to the ADA. Title II of the ADA is for state and local government. We agree with Barker and therefore reverse and remand. So Barker was right. Barker was employed as a teacher for students with disabilities at Riverside County Office of Education. And Barker was the most experienced special education teacher at the Riverside County Office of Education. In June of 2005, Barker's superiors first learned that Barker had filed the class discrimination complaint with the U.S. Department of Education's Office for Civil Rights, OCR, I'm going to refer to it here on. In the constructive termination action now before us, Barker alleges her supervisors then retaliated against her throughout the following school year by 1. Intimidating Barker for filing the class discrimination complaint with OCR. Failing to respond to Barker's emails and phone calls. This is notorious actions for people when you ask them for ADA rights. I mean, what they do is they shut up, they glue up. It's just crazy. They deny you equal access even more. Excluding Barker from important staff meetings. I mean, this is the same thing happens to me with court. Changing Barker's work assignments to sites further from her home. You saw this on that video with Moreland. He said, "No, you can't appear remotely. You have to come in." Reducing Barker's caseload, even though the Riverside County Office of Education's alternative education disabled student population increased. So the student population increased, they reduced her caseload. Refusing to allow Barker to fill in for other teachers during their vacation. And Barker further alleged that she was constructively terminated because her supervisors subjected her to an intolerable work environment. On June 16th of that year, the OCR determined that the preponderance of the evidence showed that the Riverside County Office of Education had retaliated against Barker in violation of Section 504 and Title II. OCR further stated that advocacy on behalf of disabled students on issues related to their civil rights and filing of the OCR complaints are protected activities under Section 504 and Title II. This is a great lawsuit. This is the only one that I know of that's reached the appeals level, and the appeals court has sided with us. In August 2000, following the Riverside County Office of Education's Rule 12b-6 motion, the motion to dismiss, the district court found that Barker did not have standing to sue and dismissed her claim of prejudice. Barker timely appealed. So Barker argues that Section 504 grants standing to individuals who are retaliated against for attempting to protect the rights of disabled people, even if they themselves are not disabled. And this is true. This is how it's written. According to the Riverside County Office of Education, Section 504 was not intended to provide redress of employment claims for persons who are neither disabled themselves nor have any close relationship to a disabled person. This is a really nuanced case. You got to pay attention to how this case works, because Title I is employment. She didn't file under Title I, she filed under Title II. So this is really, there's a little tweak here. Contrary to the Riverside County Office of Education's arguments, we find that the anti-retaliation provision of Section 504 grants standing, to non-disabled people who are retaliated against for attempting to protect the rights of the disabled. So they're like, no, you're wrong. We're going to find that does. The remedies, procedures, and rights set forth in Title VI of the Civil Rights Act of 1964 shall be available to any person aggrieved by any act or failure to act by any recipient of federal assistance. That's the Section 504 anti-retaliation provision. Okay. Then 29 U.S.C. 794A, that's where that's located. Okay. Matter of fact, if it's still PDF, I can't move it up there. But the anti-retaliation provision of Title VI of the Civil Rights incorporated by Section 504 states, no, and this is similar to the ADA, but it says no recipient or other person shall intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured by Section 601 of the Civil Rights Act or this part, or because he has made a complaint, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under this part. That's 34 CFR 100.7E. This regulation applies to all rights secured by the Rehabilitation Act pursuant to 34 CFR 104.61. In other words, the anti-retaliation provision in Title VI of the Civil Rights Act has been incorporated by Rehabilitation Act so as to extend the Rehabilitation Act's protection to any individual who has been intimidated, threatened, coerced, or discriminated against for the purpose of interfering with protected rights under Title VI of the Civil Rights or Rehabilitation Act. Now, this is really, really important. How many times have I been in court and they said, well, you're not an attorney. You can't advocate for his or her civil rights. Section 504 and its anti-retaliation provisions use all-inclusive phrases, any person aggrieved and any individual, and no language further limits who any person aggrieved or any individual may be. In particular, the statutes do not include language requiring such individuals to have disabilities in order to have standing, nor do they require the protected individual to have any close relationship to a disabled person, as argued by the Riverside County Office of Education. Indeed, the use of such broad language in the statutes evinces a congressional intention to define standing to bring a private action under 504 as broadly as is permitted by Article 3 of the Constitution. While Congress could have limited the remedial provisions of the Rehabilitation Act to claims brought by or on behalf of disabled individuals, it did not do so in an apparent recognition of the fact that disabled individuals may need assistance in vindicating their rights. Assistance by who? Any person aggrieved or any individual. That's who can assist them in vindicating their rights. And I can do this shit in court too. And that's why judges don't like me. And that's why they also say that I'm practicing law without a license, which is bullshit because Congress said I could do this. Congress said you could do this. Furthermore, while not controlling authority, it is persuasive that after completing the investigation into Barker's complaint, the OCR concluded that advocacy on behalf of disabled students on issues related to their civil rights and the filing of OCR complaints are protected activities under Section 504 in Title II. Accordingly, we find that the district court erred in determination that Barker lacked standing under Section 504, and we reverse. We find that Barker does have standing under Title II for the same reasons she has standing under 504 of the Rehabilitation Act, because they're going into the ADA now. I get it. So this 42 U.S. Code 12-12132 goes with this section here. Gotcha. So then it says the anti-retaliation provisions of the Title II of the ADA state, no private or public entity shall discriminate against any individual because that individual has opposed any act or practice made unlawful by this part. That's why when the courts fuck up and they violate the ADA, I say in writing, this is opposition to an unlawful act in violation of the ADA. And I invoke 28 CFR 35.134A and also 42 U.S. Code 12203A. Let me continue reading here. Or because that individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under the act or this part. Then B, this is the power punch here. No private or public entity shall coerce, intimidate, threaten, or interfere with any individual in the exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of any right granted or protected by the act or this part. This part right here, or on account of his or her having aided or encouraged any other individual, this is what entitles you, and this is what entitles me to advocate for people with disabilities in any Title II setting, including court, where a judge has a robe on and a gavel and a sheriff is standing there with a gun, or at a police stop or wherever. It doesn't matter if it's a state or local government entity. They're covered by Title II, and you have the right to advocate for them there. That's 28 CFR 35.134. So right here it says, instead, the use of the phrase any individual, let me read up here. As in our analysis of Section 504 of the Rehabilitation Act, the language employed in the anti-retaliation provisions of Title II does not evince a congressional intent to limit standing to individuals with disabilities. Instead, the use of the phrase any individual and the absence of any language limiting standing to those with disabilities indicates Congress's intent to grant standing under Title II as broadly as is permitted by Article 3 of the Constitution. These cases are worth looking at too. Congress recognized that disabled individuals may require assistance from others to defend their rights. How about that? While Congress could have limited the remedial provisions of Title II to claims brought by or on behalf of disabled individuals, it did not do so in apparent recognition of the fact that disabled individuals may need assistance in vindicating their rights. So this is a really important distinction right here, and I put that in brackets here. The district court's reliance on Zimmerman v. Oregon Department of Justice in determining that Barker lacked standing under Title II of the ADA was misguided. In Zimmerman, that's the Zimmerman v. Oregon Department of Justice case, the plaintiff alleged that he was fired from his job because of visual impairment in violation of Title II of the ADA. Now that is a Title I claim. We held in Zimmerman that the plaintiff's claim should have been brought under Title I of the ADA instead of under Title II, because the plaintiff claimed that his employer discriminated against him because he had a disability, and employment violations are protected under Title I employment. Okay? Here, relying on Zimmerman, the district court incorrectly found that because Barker also claimed that she was discriminated against by her employer, Barker would similarly only have standing under Title I of the ADA. Contrary to the district court's finding, Barker's situation can easily be distinguished from that in Zimmerman. Unlike Zimmerman, Barker does not allege that she lost her job because her employer discriminated against her because of a disability she had. Instead, Barker alleges that she was retaliated against and subsequently lost her job because she advocated for disabled students who were receiving inadequate public services, educational services, provided by a public school, which are covered under Title II of the ADA. So she was advocating, she was aiding and encouraging another in the exercise and enjoyment of their rights, which puts this Title II entity squarely in the crosshairs. Yes, it's an employment issue, but she was discriminated against because she was aiding and encouraging another, not because she had a disability and was fired from work or wasn't accommodated at work for that disability. Get me? Having concluded that Barker has standing to pursue her retaliation claims both under Section 504 of the Rehabilitation Act and Title II of the ADA, we reverse and remand to the district court. I'm going to have some fucking fun with this. So I just want y'all to have this, okay?